little bit late, but Aziz will be here in a minute. I'm Kevin Cromash. I'm at the Chicago Center on Democracy. Thanks everyone for being here, and thanks to everyone on the Zoom. I hope you can hear me. This is kind of a different format for an event. This is not a presentation or a lecture. It's really just a space to ask questions and engage in the conversation. We're lucky to have Tom Ginsburg, and then Aziz Huq will be here in a minute from the law school. The conversation's about the 14th Amendment, and specifically the insurrection clause. Some of you have probably seen the news about Donald Trump potentially being excluded from the ballot in Maine and Colorado. So we can talk about the text of the amendment, we can talk about the history, we can talk about political ramifications, really anything you all are interested in. Just, it's meant to be pretty informal, so you can just jump in. I'd say people on Zoom, if there's a good moment, you can just unmute yourself and ask your question, or if you want, you can raise your hand and we'll try to signal. But I think that's it. So Tom, maybe you can get us started. Just tell us a little bit about the 14th Amendment, and then anyone can jump in.
Great. Thank you very much. Thanks for doing this, Kevin. It's a great, obviously great day to be doing this. It's being argued today. So just as background, the 14th Amendment is definitely in the top 10 of amendments. It's really an important amendment. It's the source of our doctrines on equal protection of the laws, due process clause, privileges and immunities. It changed the fundamental relationship between Americans and their government. And because for the first time, it incorporated all these things that are in the Bill of Rights that we all know. The way the Bill of Rights is written, it's all directed at Congress. So that meant states could violate all those rights. And so it's only with the 14th Amendment that we get this monumental change. And thus is kind of a second founding, as many people say, about the Constitution and relationship between citizens and government. Now, that's not until very recently, no one paid any attention to Section 3. It had not really been litigated since 1868 or 9. I can't remember when Griffin's case is. But there was, it was obviously really important in the aftermath of the Civil War. You had many sitting officers who had fought for the Confederacy, and there was genuine disqualifications that occurred at the Tennessee Supreme Court and such as there was a lot of activity around it. And as with so many things in the few years after its adoption, we see a great change in the approach of the United States away from what we would now call transitional justice in countries that are undergoing democratization, where you punish the people who committed the acts in the past, towards really setting that project aside with the end of Reconstruction and the adoption of what's called euphemistically redemption of the southern states. So 14th Amendment is like adopted right in there. Who would have ever thought? It's the funny thing about the constitutional text. You got language in there, that's dormant, that's in desuetude, it will never matter. All of a sudden it has come to the fore precisely because of the Colorado cases and after January 6th, there was new attention. I'll just say one other thing, maybe, and then and the format is that they ask questions.
Yeah.
I mean, I'll just say something about the two cases. So there's a case in the 1860s, Griffin's case, where Salmon Chase, who was a justice with later Chief Justice with political ambitions, basically says this is not a self-executing amendment. In other words, there has to be a statute of Congress for us to use it for disqualification. And that was a change from the understanding up to that point. People were being disqualified without an act of Congress. But very interestingly, after January 6th, I think in late 2021 or 2022, another guy named Griffin was disqualified. He was a New Mexico County commissioner who had been part of the insurrection. And a New Mexico state judge directly applying this constitutional language says, hey, you committed an insurrection, you swore an oath to protect the Constitution, you're out of there. And he was removed. So 150 years apart, almost, two different Griffins. That's the kind of background in terms of precedent and such. Perhaps we should just open it up and see what questions people have. Yes.
I'm very sorry for being late.
Yeah. It's a big media day, obviously, around this issue. So, and maybe you could say your name and what you're studying.
For sure. So I'm Shub, and I'm a first year.
Thank you for this amazing discussion. My question is, Section 3 includes a list of positions that the amendment applies to, and those positions does not include either the president or the vice president of the United States.
Yeah. Great. So this gets to the question, and I'll read the language for everybody. No person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, if you've taken an oath and then engaged in insurrection. So this is a big legal debate. It's one of the 3 or 4 major legal issues which are being discussed. You certainly can't hold an office under the United States, but is the presidency an office under the United States? Is the president an officer under the United States, or is the president above? And this is a term that's used, and I'll turn to Aziz, who knows much more about it than me, but it's a term used in various ways in the Constitution. So in the impeachment clause, it refers to office. And clearly the impeachment clause would apply to the president, that you'd be removed from office. But then there are other places where it seems to refer not to the president and vice president, but to sort of appointees, people who have, either cabinet officers or, lower officers. And this is also debated in administrative law. What is an officer of the United States? And so that is the question. And I have my views about it. I don't know if you want to comment on the legal question.
Sure. Well, I think it would be helpful to distinguish, maybe ask you to distinguish between 2 different questions that you could be asking. Section 3 has 2 lists of officials. The first list concerns what might be thought of as the future regarding question of which officers a prohibition attaches to. So which officers in the future can you not hold? The second question, if you read down the clause, is about which offices a person might have held in the past such that they swore an oath, and the fact that they swore the oath and held the office triggers, as a past act, the disqualification. Now, those are 2 separate arguments. There's the future regarding question as to from which offices are people covered by Section 3 disqualified. And there's the backward regarding question of which offices might you have held in the past that trigger the disqualification in the future. The Trump briefs make an argument about the second, but not the first question. But I don't know which one you're asking about.
Well, I mean, I just felt that I was asking for the first, actually, since it mentions specific positions like senator or representative in Congress, elector of president and vice president, but it does not include the president.
Yeah. Maybe I'll just say one thing, which is neither of us is a proponent of the constitutional interpretive theory known as originalism. It strikes me as rather obvious from any kind of purposivist or teleological approach to interpretation that it would be really nuts if someone couldn't be an elector of the president because they'd engaged in insurrection, but you could be president after engaging in insurrection. Jefferson Davis, under that theory, could have become president of the country, but not served as an elector. So that's always struck me as just odd. That would be a weird outcome oriented interpretation. Of course, a literal or textualist approach would take it through.
So let's take the first clause, which is the future regarding question that you asked. And let's notice that it breaks down into 3 different categories. The first are elected federal officials. The second are electors, right? So those are people who are convened every 4 years to constitute the Electoral College and cast a vote for the persons who will be the president and the vice president. And the third is a sweeping catch-all of any office, civil or military, under either, I'm adding the word either, the United States or under any state. So your argument is, or the argument you put on the table, not your argument, is the president is not mentioned. Why should that matter? There's one clause here about federal elected officials. There's one clause here about this class of people who are periodically convened in order to exercise the power of the Electoral College. And then there is a sweeping provision that begins with the word any. And it applies to offices. It extends to any office that is civil or military. And it applies whether that office is an office of the United States or whether it is an office of a state government. Would any, so that Tom referred to different kinds of interpretive traditions. The dominant version of originalism at the moment on the Supreme Court is called original public meaning originalism. What was the understanding of the framers? What was the understanding that an ordinary, reasonably well-read person would have had at the time that the ratification occurred of this language? Would any reasonably informed individual in 1868 have thought that the language, any office, civil or military, under the United States or any state, excluded the president? Well, why would they have thought that? The word any is not a word that bespeaks limitation. Any means any. The president, among the limited array of obligations imposed by Article 2 of the Constitution, is denominated Commander-in-Chief. I would have thought that the Commander-in-Chief was a military office. No reasonable reader at the time that this language was crafted, looking at the text of the Constitution, in my view, would have read the clause that the third category of the clause that you're picking out to exclude presidents. And the fact that other offices are mentioned is, as a matter of text, a red herring. The other offices that are mentioned, legislators, electors, are categorically different, are categorically distinct from civil and military offices pursuant to or existing within the executive branch. So the argument that had the framers intended to cover the president, they would have explicitly mentioned that office, is contradicted by the word any, and is contradicted by the fact that this explicitly covers military offices, and the only military office mentioned in the Constitution is the Commander-in-Chief. Is that helpful?
Thank you.
Yes.
Hi, yeah, I'm Jules, I'm a first year, but you guys have just from original meaning, original intent, originalism, and also just practicality, you guys both seem really sure that there is one right interpretation here. Yet we're still having a really big political debate about it. So where's that other argument come from?
Yeah, first.
Yeah, you can go.
So first of all, we've just been talking about one clause. There's better and worse arguments that have been laid out in the controversy today. If it was obvious, there might not be a legal case, though these days you never know. But I guess what we've said so far is that we don't think the officer argument is a very good one. We don't think that there's really, I would say, even a good faith argument to be made on the other side. There are other ones. Is the clause self-execute, or does it require a statute? That's something that I think we can certainly talk about. What counts as insurrection? How do we determine that factual question? What is the predicate for that? So I guess that's what I'd say. Yeah, Kevin.
I'm Kevin. I'm a first year at the college, and So my question was, I was looking at the petition, the cert petition, and the questions presented was really a non-question. It was literally like, did the Colorado Supreme Court err in its decision? Which, like, every question presented is basically that. But my question is, like, what can the Supreme Court actually like decide? Because the Colorado Supreme Court, the dissent, I think for the most part, was like focused on state law, like procedural aspects of state law, not the 14th Amendment itself. And combined with the fact that the district court made, not the state lower court made the factual determination that there was insurrection. So, like, I don't, like, my question would be, like, what can, like, the Supreme Court actually do in this? Like, how can it actually rule?
So again, there's two questions, Kevin, that you're asking. So the first question is about what are the scope of issues available to the court? And the second question is about what is the potential range of downstream consequences of a ruling? What the court can do can be about what issues have come to it, or it can be about what it can do at the back end with respect to the work. So which is the question? Those are two separate questions.
Can you repeat this?
I heard him asking the procedural question, like what is actually being reviewed?
I think my question is basically like,
well,
what can the
let me
court
do that
actually
one.
rule on?
Yeah. Let me do that one. I can do that one.
Yes.
Yeah.
Okay. Anderson, Anderson, and the 5 other Republican primary voters, registered Republicans in Colorado, challenged the inclusion, challenged the Secretary of State's decision to list Trump on the primary ballot. Did not challenge the decision about who is listed on the general election ballot. The court in Colorado, Supreme Court, held that although the Secretary of State of Colorado does not have an independent obligation to inquire into the qualifications of the person who is listed, where it is the case that a person is unqualified to appear on a relevant ballot, whether state law requires that that person not be listed. So the question, the actual question before the Colorado court is narrow in 2 separate ways. First, the actual question is a question of Colorado state election law. The question is whether who it is that Colorado state election law allows to appear on a ballot. And Colorado has its own qualification rules, but it also, at least for certain offices, absorbs in, as a matter of the supremacy clause, federal law. So that's how the question of Section 14 enters in. But notice that it's gate kept by the Colorado law. Okay. The second limitation is, as I have just said, the only ballots that were at stake were the primary ballots. In Colorado, the Secretary of State is under an obligation as a matter of federal law, the Uniform Voters and Overseas Military Act, to print ballots for overseas and military voters roughly a month and change prior to a primary. The deadline for printing those ballots was January the 4th. The Colorado Supreme Court stayed their decision and directed the Colorado Supreme Court to include Trump's name on the primary ballots. Excuse me, the Secretary of State's to include Trump's name on the overseas ballots and also the mail-in ballots that were mailed this past week. There is no question that Trump's name appears on the primary ballot in Colorado. That's already happened. It happened between the Colorado Supreme Court ruling and today. Okay?
Wait, question really quickly. Doesn't that make the case moot, or is there like a?
Oh, you see the problem.
Yeah.
And now you see we go back to the way you started,
right?
Which is why is the question presented in the petition for cert written in the way that it's written?
Right.
Nobody who is arguing this case on either this is an instance in which both the plaintiffs and the defendants in the case have an interest in colluding in order to obscure a necessary jurisdictional limitation on the court. The plaintiffs and the defendants want to say, this is a case about every instance in which a state or federal official may or may not include or exclude President Trump from the ballot. Notice further that even if the court holds that Trump is disqualified, that decision doesn't in any way bind, for example, the Secretary of State in Michigan. The Secretary of State in Michigan could say, as a function of the Michigan law respecting who appears on the ballot, I don't have discretion at this point to exclude people who are disqualified under Section 3 because of the way that the state law is written. That's out of my purview. It's in the purview of somebody else. And indeed, Jocelyn Benson, who is the Secretary of State in Michigan, has said that. So in the only state in which Trump might be excluded from the ballot, which is counted as one of the swing states for the purposes of the 2024 election, the Secretary of State has said she's not going to do it. Now that might change with a ruling from the US Supreme Court. But the point here is, the parties have teed this up as a case about Trump's eligibility for the general election ballot. And the facts of the case are only about a ballot that for which all of the paper ballots have in fact been printed, such that there is no live dispute. So the case, because the parties don't want it to be moved, has been framed and argued in a way that makes it seem as if it's about everything. But if the court was legalistic, it would be about nothing.
Thank you.
Can I ask a follow-up to it? I'm Tony, but I'm the executive director of the Forum on Free and Clear Expression in that capacity with Professor Ginsburg. You use, I think, as you use the term, excuse me, Professor Huq, you use the term the supremacy clause, by which, you know, I'm not trained in the law. Is that referring to incorporation essentially?
No.
Okay.
No,
So
the supremacy clause is an element of the original Constitution that directs, and it speaks directly to state judges, actually, but it's understood to speak to state officials more generally, and directs state judges, the state officials generally, to take the federal Constitution, federal law, and treaties as the supreme law of the land that supersedes any contravening state law. So the way that that is understood, the way that that would operate in this context would be, I don't know the exact language of the Colorado election statute. Shocker. But let's say it says something like, only qualified individuals are, only qualified candidates can appear on this primary ballot. The word qualified would be understood by force of the supremacy clause to index both federal and state qualifications, right? But even that question of what it indexes is a question of state law, right? And I can come up with an argument. I don't think this was the argument that no one thought this in Colorado, that you were, although this is the position in Michigan, that if there's a word qualified in the Michigan statute, we're just talking about Michigan law. And there's somebody else upstream who's going to do the federal law question. And that's a perfectly valid way of thinking about the allocation of authority. But and to think otherwise, I think you'd have to view the supremacy clause as imposing a mandate at the stage of the primary. By the way, you know what the effect of a primary ballot is? The primary ballot goes to the RNC, and the RNC decides how many delegates to assign to which candidates at the Republican National Convention. Like, that's what's at stake in the primary. It's not who's on the general ballot, right? So we're like several layers removed in the actual litigation. But I have to say, I would be surprised if anyone gives two hoots about any of these arguments tomorrow.
And that's the follow-up question. So you also, I'm not sure if I understood this correctly, but in responding to Kevin, you mentioned like the narrow legalistic constraint on a ruling that addresses the questions that are presented to the court. And I guess that opens the question of whether, and perhaps it's unlikely, a ruling could go beyond the questions that are presented to the court. And if that's even foreseeable, what is likely to be considered? The scope of the supremacy clause, the election law, allocations of elector, like what doesn't seem likely from my reading, but is that
my view
into it?
I mean, do you want to? Well, my view is that I don't think the court will take up the mootness question that Kevin identified. There is also a question of what's called the statutory jurisdiction of the court. The court needs to have power under a federal statute to hear a case. The power of the Supreme Court to hear cases that come from a state Supreme Court is limited. It's limited, for example, to cases in which a federal right is negated, or a federal statute is struck down, or a state statute is not enforced because a federal statute is seen as supervening upon it. It's not clear to me that any of those conditions are satisfied, right? So there's actually two threshold jurisdictional questions that mean that the court ought not to hear the case. I suspect that both of those will be ignored. So I suspect we'll hear nothing about those two tomorrow. I suspect that I think that the most likely path for the court to take, which I think we're on the same page about this, is that I think it will be politically too difficult for the court to say that there was so actually Trump's lawyers don't quite argue, and I think that they probably waived the argument that what happened on January 6th is not an insurrection, right? And I think what their argument is that what he did did not count as insurrectionary conduct, right? Which we can talk about that, right? I think that talking about that for the court's going to be really hard. I think the official argument that he's not an official because the president is not an officer. I think it requires such a willing suspension of disbelief that even were we in the realm of high fantasy, it would be hard to manage. So for that reason, it's not, the court does do things that I think require willing suspension of disbelief. Is this a case where it's going to do that? I'm skeptical.
Yeah, that's right. In the back here.
My name is Roger. Two things. One, for the room, I read the historians in the history.
Yes, I read that too.
And it's very compelling. And particularly with respect to those people at the time that were supporting a run for the presidency by Jefferson Davis. And Davis never ran for president because of the article, Amendment 14 section. So that's just, to me, it's very clear. The question on this last one was, I've looked at the relief provision, the bicameral 2/3 relief, and an act that was placed for one person called it, was relieved of his political disability. So my view is that, in effect, Trump, when he's appealing this, is basically saying, Supreme Court, please find that I'm not suffering from the political disability.
So Roger's actually,
yes.
So Roger's referring to another clause in Section 3, which says that if you have been disqualified, Congress can, by a vote of 2/3 of each house, remove such disability. So that meant, if Jefferson Davis had been disqualified, somehow 2/3 of Congress wanted him to run, they could remove it. So I don't think that would be the Trump argument, because their argument is that he's not disqualified, it's not directly applicable to begin with. This Colorado Secretary of State has no ability to even read this provision without a federal statute. So it's not that there's, and because also Trump would never have gotten such a 2/3 majority to remove such disability. So I don't think that's the big operative thing here. And let's get some other questions. I also see that there's some questions in the chat. I don't know are you running that?
Yeah.
Why don't we do one from the chat and then to the room? Okay.
Yeah, there's a question from Jerry in the chat, and it's basically going back to the definition of what an insurrection is.
Yeah.
And if you can define, so he's basically saying that some people might not define this as an insurrection, and who gets to make that decision.
Yeah. You want to talk about the insurrection statute? I mean,
No, I think that was separate.
Okay, so the question of who that's defined, and that gets to the question of self-execution. So originally it was understood that this provision, like the clause that says you have to be 35 years old to run for president, is just self-executing. The Secretary of State who receives an application from a 25-year-old should reject that without requiring a federal statute to that effect or anything like that. And so, and of course, at that time, they knew what the insurrection was. Now, there is some argument that has been made in some quarters that, well, you know, it's not an insurrection unless it rises to the level of the Civil War, And that, again, doesn't strike me as passing the sniff test. The language is in there. It's still operative. Is it directly self-executing, in which case every individual officer, every Secretary of State has to kind of interpret that. There is, of course, also the possibility of being convicted under the insurrection statute or sedition statute, something like that, where you have a criminal court that decides that this act was insurrection. And, you know, that is just a matter of juries finding it, essentially, and judges defining it. And then, of course, the alternative view being, and this is why the case is coming up and why they will, I think, decide this. We can't possibly operate with 50 different secretaries of state and attorneys general deciding whether insurrection is or whether this conduct violated it. We can't have Trump appearing on the ballot in some states and not others. It's a national election after all. We need a uniform answer, and that is the moment that we're in.
So I have a slightly different view on one point that Tom raised, and then I'll try and elaborate on the second point that he raised. So imagine that Tom murders me.
I mean, just for my half of the royalties on the book.
He gets me royalties.
Yeah,
imagine he murders me. It's a federal statute that criminalizes murder, right? The federal statute is self-executing in the sense that once Tom has murdered me, he's violated the statute. He is in at least one sense of the word, a criminal under federal law. However, that doesn't have any consequence as a matter of law. Doesn't mean that he can be locked up. Doesn't mean that he can be sanctioned in any way, unless there is a particular process. So someone can be have a status in law, criminal, but the consequences of that status might require a process. My view, and as I read the briefs, I actually think this is the consensus view, and it gets around this tricky In re Griffin case, which I think is a train wreck. Anyway, so let's not talk about it.
Yeah.
I think that is the right way to think about this. That Section 3 says if you do X or Y or Z, you have violated. You are an insurrectionist. Let's just use that word, right? And there are consequences that flow from that. Just as the federal criminal law says, if you commit a murder, you are a murderer, and these consequences follow, right? But that status does not mean that everyone else can treat you as a murderer, lock you away, punish you, apply civil or criminal forfeiture laws to you, whatever it is, right? There has to be, in addition, some process whereby the facts in the world are translated into legal facts, legal acts respecting certain facts that have the force of law. So as I understand the briefs, and as I understand that, I think the best version of the argument, it's that it may well be the case that Section 3 was violated, but that doesn't tell us yet how that violation translates into a legal consequence. We need to know that second piece of it, right? And I think the argument, the best argument runs as follows. I think it has two steps. So first, at the time that the 14th Amendment was adopted, there are certain cases where it is self-evident and no one needs to argue about its application. And therefore, there was just no need for a mechanism with respect to, let's say, Jefferson Davis and some coterie of people of that kind. But then there start to be other mechanisms in the 1870s and 1880s, such as there was a mechanism called you could file for something called a quo warranto writ, a quo warranto writ is an old English legal mechanism whereby someone can say, show me by what warrant, quo warranto, you are able to take this official act. Show me essentially your bona fides as an official. And the quo warranto statute mechanism was a procedural vehicle for essentially checking qualifications. And there's at least a couple of cases in which it was used in that way. Later on, Congress takes away the quo warranto statute and enacts the Criminal Insurrection Act statute. The Criminal Insurrection Act statute, which says thou shalt not commit insurrection, has, as one of its consequences, as one of its entailments of conviction, disqualification under Section 3. Now, there is a case in federal law. I know all of you spent nights awake about this case. The National Sea Climbers Association case. The Sea Climbers. The Sea Climbers Association case says that when federal law picks out one remedial pathway, it is a necessary negative inference that it excludes other remedial pathways. You can take the National Sea Climbers logic of the identification of one pathway leads to the negative inference with respect to other pathways and apply it to the insurrection statute, which I think is 2383, although I may be getting the numbers wrong. And you can say, Congress said if there's going to be disqualification, it's got to run through this pathway. Oh, and by the way, Jack Smith chose not to charge Trump with insurrection. The 4 counts in the DC case, in which the DC Circuit Court ruled that there is no magic secret get out of jail card for free, hidden in Article 2 of the Constitution yesterday. So Jack Smith did not identify the Insurrection Act criminal statute as one of the 4 offenses that he charged. And indeed, none of the, whatever it is, 300 odd January 6 rioters have been charged with insurrection. Now, there's reason for that. In part, it goes back to this problem that we don't exactly know what an insurrection is, and there's competing and divergent historical evidence, and different people have different views on it. That's plainly a hard question of interpretation. But this question of having done one thing, has Congress implicitly excluded the others, is, I think, going to be very attractive. It has its problems, but it's going to be especially attractive because the alternative is 50 different state secretaries of state doing their own thing.
Yeah. And we've already seen divergence.
Yeah.
Yeah, I was just.
What's your name?
I was wondering if the fact that the clause in question has that part where the 2/3 of both houses can override it. Does that sort of imply that there is some self-execution to it?
Yeah, but that doesn't defeat the point that I just made, right? Remember, I drew this distinction between facts in the world and the facts as the law has found them to be through the registered, recognized procedures of the law, right? Call it the demotic. You know what the word demotic means. I know you know. Demotic facts. In case it's in like property class. I use the word demotic, and I tell them they have to know what it means. Wow. There's the demotic facts, and there's the legal facts, right? So what you say may well be true of the demotic facts, but it doesn't tell us what the legal facts should be, or how the legal facts are discovered.
George.
Yeah, I'm George. I'm also at the law school. So this insurrection statute, which and the CLAM, what association?
National Sea Climbers
Association case. And you may have covered this already. I came in about 10 minutes late, but the language of Article 3 specifically mentions engaging in insurrection or providing aid or comfort to those who do. That's paraphrasing, but if it's taken to mean you can that article only applies under being criminally charged with the act of insurrection, wouldn't the language of providing aid or comfort, which, you know, implicitly seems to expand the scope of Article 3's applicability, wouldn't that just be limiting the amendment?
Of course, it's aid and comfort to the enemies thereof, enemies of the United States. So when you think about that, that's even more expansive, right? Who are the enemies of the United States? What is providing aid and comfort? So, you know, I think you're right. I mean, the way I sometimes wonder about this is, well, you know, someone 25 years old shows up and goes to the Secretary of State's office. No one makes the argument. So what are the category of things for where we need more articulation, where we need some sort of process, if you will?
Yeah, but I think, but go back to the criminal. I'm going to use the criminal law example again. I have no reason to believe that this is the direction the argument will go in tomorrow. It's just the one that I find the most useful in thinking about it. Go back to the criminal law example. Do crimes happen without them being punished and resulting in a conviction? Yeah. Okay. So there's a gap between the facts on the ground and the facts as the law find them, right? All the time. And in fact, that's a necessary inference from giving Congress the power to decide on how Section 3 is implemented. And remember that Section 5 of the 14th Amendment contains a clause that grants to Congress what traditionally has been understood to be very broad discretion about how to enforce any of the foregoing clauses of the 14th Amendment. So, given the persistent gap between the facts on the ground and the facts as the law has found them, given that Congress has the power to decide, and maybe decide, you know, we're only going to have a disqualification for insurrection or rebellion. We're not going to have a mechanism for aiding or abetting, right? Notice that they could have done that if they had added in the language, added in that same disqualification language to the federal statute that made conspiracy to engage in insurrection a criminal offense. I'm sure that statute exists. And notice that there's a really interesting question of statutory interpretation. Let's say that you've got there's the insurrection statute, right? And the insurrection statute says you can be punished by disqualification. And then there's the general conspiracy statute that says you can be charged for conspiring. You and I agree, and we take one overt act, right? And that's enough, provided that we're conspiring to commit one of the other indexed federal offenses. But for the conspiracy statute, disqualification is not listed as a penalty. Can you shoehorn disqualification for the class of people who are aiding and abetting into the federal criminal statutory scheme by saying, if you conspire to commit insurrection, you're making yourself, one of the potential penalties, given the way the statute is written, would be disqualification. Do you see the
yes,
how that works?
Yeah, I guess the one follow-up question I would have, because it does invoke statutory interpretation, is when the insurrection clause or the insurrection statute was being drafted, was this after Clam Jammers Association?
Sea clammers, George. Sea clammers.
Sorry.
Remember the sea clammers.
Was this after that had been issued and Congress had some?
I don't know. And more generally, so sea clammers has language about you need to look at evidence of what Congress's intent was. So sea clammers is written at a time when the court read the legislative record in order to make determinations of congressional intent. As you know, the Roberts Court does not do that. They don't believe in legislative intent. They say legislative intent is a fiction. They are loath to look at legislative records. So how do you apply the sea clammers rule, which is a rule that hinges upon legislative intent, in a world in which the court does not believe in legislative intent? It thinks it's a not useful fiction, right? I think is a hard question.
Let's go online if there are other questions. Oh, there aren't. Okay. Anyone else in the room? Yeah, we can go back to you, Roger.
Just to follow up, am I hearing you correctly that you're saying that the Section 5 in Congress may put in enforcement legislation would allow Congress to elevate the standard of proof from preponderance to beyond reasonable doubt? My recollection is that the Colorado courts, district court, when making their findings, made a preponderance of the evidence finding with respect to the insurrection question.
I think the argument for, so the way, I think the technical term for it would be the federal preemption of the state remedial mechanism here would necessarily imply that Congress has the power to determine the correct standard of proof.
Yeah. Oh, let's go for, why do we have someone who hasn't asked a question? Go ahead.
Hi, and I work with the Center for Effective Government. I was just curious, out of the defenses that Trump's counsel have made and might make to this court, is there one that you think that this court is inclined to find most compelling?
You first.
Well, yes, the sea farmers. My answer to every question.
Yeah. Yeah.
Yeah, that is an argument that's in the briefs.
Yeah. And there is also the factual question of, he obviously incited an insurrection. For Colorado, that wasn't a problem. That clearly met the standard. But there is a kind of a factual question of what does it really mean to engage or give aid and comfort? Were the insurrectors the enemies thereof of the United States? I mean, I think that might be the better way. I mean, I think we both agree that the officer argument is not a very good one. I think the self-execution one is a good one, given that we have Griffin's case. Everyone thinks it's a bad case, but it's still the federal precedent. And also, I think there is a functional case for some national uniformity here. But I guess we'll see. We'll see what they do. You have a prediction in terms of where they will go with regard to this question of the factual thing? Or
so one of the things that's, I think, interesting, and that if you'd asked me even this morning, I would have said they're not going to touch with a 10-foot pole. They're going to have some very, very anodyne description of the facts that uses the word allegedly in front of every sentence, or putatively, or some synonym thereof. Yesterday, the DC Circuit ruled that Trump doesn't have immunity from criminal prosecution. And I've always thought the criminal prosecutions are much more important than the Section 3 actions. And I continue to think that. And the DC Circuit's opinion, the DC Circuit is the intermediate court, sits between the US Supreme Court and the trial court, where Judge Tanya Chutkin is presiding over the trial with respect to the 4 offenses in and around election interference that Jack Smith has brought against Trump. The DC Circuit Court of Appeals, in a unanimous, it's what's called a per curiam opinion, which is every single one of us, the 3 judges on the panel, 2 Democrats and a Republican, stand behind this. So they write a per curiam opinion rejecting Trump's claims for immunity on every ground. It is a remarkably thorough opinion. It takes a hammer and nails to every single argument that he makes. But what is really startling is the description that they offer of his acts on January 6th. They do not hold back. I mean, they're very careful. It's all alleged. It's all, if these allegations are true. But there's a place in the opinion where they say, we cannot imagine a more serious assault on American democracy. And American democracy, through the electoral process, is the ultimate and the necessary check on executive power, which has got to be right. So this is the functional argument, or a kind of functional argument. But it is an opinion that does not bait its breath when it comes to saying what happened on January 6th. And I do wonder, now that the DC Circuit has done this, now it's said things, does that open up a little bit more rhetorical space for, I can't imagine it's going to be all justices, but some of the justices, and you can imagine Roberts being the person who writes this. Does Roberts write an opinion that says, this is what happened on January 6th, this is how many people died, this is what happened after whatever it was at 219 Trump tweets. It's time for Mike Pence to do his job. And there's literally in the minutes after that, a wave of people who are receiving that tweet pushing into the Capitol. Right. That, by the way, that is the best argument for insurrection. That tweet.
And the lack of one thereafter at 225. So
Yeah,
I didn't mean that.
Yeah. And I would say that under ordinary circumstances, the description in the Trump's lawyers' briefs of what happened that day, I think would be subject to sanctions because the brief describes what happens at the circle and then jumps to the tweet at 5 o'clock and says nothing about what happened in between, which I think is a culpable omission and is not one that a good faith, a lawyer acting in good faith. I think that a lawyer is directed to the lawsuit. I think that if you're a lawyer, you have an obligation to be as candid as you conceivably can about the facts and not to try and materially mislead. I mean, obviously, this is not a case in which the court, if it wants to, is likely to be materially misled. Nonetheless, I don't think you should even try or list in that direction.
Yeah, there's a subtext of your analysis here, which is what's going to happen in terms of the court itself, the court's reputation, the court. And I got a question the other day. Well, what if this is not a unanimous decision? What does that do to the court? What if it's 6-3 on partisan lines? Then it really is going to not help. It's going to further hurt the reputation of the court, which is already completely bimodal. And at its lowest point since they've been tracking, it's below 50% of people approve of the court's performance, more disapprove than approve, which has never happened for the U.S. Supreme Court. And it's always the case for Congress, by the way, and often for presidents, but not for the court.
What if it's so you can imagine, so the court writes per curiams too.
Yeah.
Right. Well, if there's a per curiam in this case, and Roberts is in the majority, he's written per curiam.
Yeah, that's right.
You can imagine this case as a per curiam going off on, we're not going to hear this case because of the mechanism point, CC clamors. And then you can imagine a concurrence from, let's say, Thomas, which says, I actually think that this case should go off on he's not an insurrectionist point, and that tells some story of what happened on January 6th that bears fleeting resemblance to the empirical world. And then you can imagine another concurrence from Sotomayor saying, oh, and here's what actually happened. I actually think that's the most likely outcome.
Interesting.
Where you get a sort of majority, and then you get a kind of like the long comet's tail of disagreement and flashing conflict. I don't know what that does. I don't know what, people don't know who the Supreme Court justices are.
But it would be better to have a united opinion that was stating facts in the way that you said in your last answer.
Which is what the DC Circuit did.
Right, exactly.
But I don't think they'll get that.
Yeah, please.
Just building off of what you said about Justice Thomas, for instance, what do you make of the arguments that Thomas, because of the relationship with his wife, who's involved with the whole demonstration, should actually recuse himself?
The Supreme Court justices recuse themselves when their 401k portfolio requires them.
In the back.
Yeah.
Please tell us who you are. I forgot.
Oh, sure. Yeah, I'm Brazier. I'm a third-year medical student. My question was how this relates to the Article 3 treason cases. I know obviously our Amendment 14 has the power to withhold people from certain offices, so it makes sense if that's being legislated. But I would imagine that some of the treason type talk could also have some relation, and I was hoping you could speak to that.
As you know me.
I don't know what treason case you're thinking about.
Well, not a case, but just I would imagine that there's. Could you speak to if in any way Article 3 is related to this case at all?
Well, the Constitution does have a treason. If it prohibits treason, it has a very high evidentiary standard for it, and it's in impeachment. Right? You can be impeached for treason.
No, it's so that the framers were one of the framers' concerns was the politicization of criminal law. And one of the mechanisms installed to mitigate that was a rule for, in particular, treason prosecution, which were thought of as standing at the peak of politicization risk when it came to the criminal justice system, that a treason prosecution could only be brought with extraordinary species of evidence, particularly eyewitness evidence. Treason has been conventionally understood as a crime that occurs when there is an external enemy of the United States. So, for example, during the Quasi War in the late 1700s, the early 1800s, maybe France is the enemy, right? During World War II, both Germany and Japan were enemies. Maybe during the Civil War, the Confederacy is the enemy, although that turns out to be complicated, because if you depict the Confederacy as the enemy, are you thereby recognizing the legitimacy of secession, which the legitimacy of secession was persistently denied on the northern side, right? So treason is an offense that speaks foreign entanglements in a way that is not crisply present in the Civil War context.
But I would like to add one thing, looking it up. So they define treason, levying war against the United States or adhering to their enemies, the enemies of the United States, giving them aid and comfort. So you do have this aid and comfort of the enemies of the United States, which is common language. And there is, of course, an approach to constitutional interpretation which looks for harmonizing the use of the same terms in different parts of the text. So you can imagine that Trump would say, look, it's used there. That's clearly talking about foreign enemies. Therefore, the aid and comfort is not applicable to me in my behavior. We'll see. Do we have time for any more?
I'd say we're at 1 o'clock, so I think we should wrap up.
All right, why don't we wrap up? Thank you all for coming. We'll stick around for a couple minutes if people have other questions. Thanks.